Please take a moment to like, comment on, share, and subscribe to my video. I value your support. Make sure you watch to the very end. Now, let's get right to the matter. The ongoing legal battle between Ripple Labs and the government reached a new level of intensity when the U.S. Securities and Exchange Commission advanced its position by requesting remedies and entering a final judgment. This motion demands a $2 billion fine against Ripple for a series of comments made on X, formerly known as Twitter. XRP advocate Fred Rizpoi has provided an in-depth examination of the SEC's motion. Rizpoli's analysis offers a unique insight into. The statement highlights the gravity of the situation for Ripple, while also pointing to the predictability of the steps taken by the SEC. Additionally, Rizpoi provides some insight into how the U.S. Securities and Exchange Commission described Ripple's business practices. Despite the growing legal scrutiny, Rizzoli has continued to exploit XRP sales as the company's primary source of revenue. This is especially true given his detailed exit assertions. Despite ongoing litigation and the financial, these acquisitions represent Ripple's primary source of income, according to Discovery Assistance. Has 180 contracts signed with institutional buyers since the XRP case started in December 2020. An XRP supporting attorney has forecasted two different results. The classification of the on-demand liquidity is an additional vital component of the increased policy analysis. The legal assessment of whether these transactions qualify as illegal sales or are permitted by law is a significant aspect that could impact Ripple's operational flexibility, and if Ripple is found to be in the right regarding the amount owed, the company may be limited in what it can do moving forward, which might lead to an appeal to a higher court. In a brief released by the U.S. Securities and Exchange Commission, an alternative viewpoint on the appropriate fines and penalties is presented. This perspective on Ripple, the blockchain company, is different from what the executives of the company are arguing in a document that was filed on March 25th to the U.S. District Court for the Southern District of New York. The CC's attorneys suggested that Ripple pay a total of about $1.9 billion, and the regulator found that the fines and penalties were justified because Ripple continued to sell XRP despite legal warnings. The filing was in line with what Ripple Chief Legal Officer Stuart Alderorai announced would be made public in a post published on March 25th, which was roughly $2 billion in fines and penalties. Ripple is well positioned to make a huge civil. The author notes that it was alleged by Alderorai that the SEC was planning to punish and intimidate Ripple. The company was expected to respond to the proposed judgment in April. According to the order, the only way to make Ripple reconsider is to impose a heavy fine and restore the ill-gotten riches it made from its crimes. This is why the penalty is justified for two reasons. First, a civil penalty should not be just the cost of doing business for a securities law violator, as the Second Circuit has ruled, and second, the need for deterrence is evident given Ripple's enormous amount of unregistered sales of XRP over the last 3 years.